Mike Gill, State of Corruption. Now, we just released a video 48 hours ago, setting up for the hearing I had with Judge Anderson yesterday. Right, the extortion judge. You've seen Judge Anderson, the video, red-handed. You've seen Judge Anderson that I just set up exactly what was going to happen within the last 48 hours. What you're going to see is a hearing. Wiggins and Norrie, this guy Hilliard. Hilliard is one of the most corrupt attorneys. He was the New England Bar Association president. He was tied in with McHugh, the judge, with Ross. They go back for 30, 40 years. The whole thing was corrupt. We couldn't get a witness. They sent them all out of town. Dalla Sedgwick, you remember her? Sweaty and modest. She was my lawyer at the time. She's the one that said that it was corrupt in writing. There's no accidents that this was fraud. I caught Ross on the forgery on the fee agreement. Fraud. They have to be taking me down. These are the same people. Remember, I turned 50 million down. Ross is on the list. Walker's on the list. Wiggins and Norrie, the people suing me. It's leverage, it's extortion because I said no. If you won't take the money, they have to move so that I can't move. Mortgage Specialist has been sponsoring State of Corruption. They have to stop State of Corruption. What you're going to see now, that's in Brentwood, but with Anderson, is straight up extortion. This was for 3 weeks of a bill that Dalla Sedgwick told me, and you can see it, and I'll post it in the back, her statements about how it was corrupt, how they were stealing our money, how they even lied about the money I owed them, and that they were working together. That's what they're leveraging me with, and I was only sleeping with it at the time. That's how I got the information. I'll post the love letters if you want, but that's what broke that open. And she broke the code and had to go into hiding. Watch this hearing. I'll break into it in the middle because you're going to see something. They've incriminated themselves. This piece, this hearing, is the evidence. There's the one when you ask, how can we do this? By collectively bringing them in the same court of Brentwood is doing that for them to protecting the drug dealers with Shaheen and Gordon. Anderson, Francois, the judges in Brentwood, with Delker. We get everybody. Now you tell me if this doesn't look corrupt. And if you tell me if you ever spent $250,000 for a month in a divorce.
The board is now in session. You may be seated.
Okay, we're here in the matter of Wiggins and Norrie versus Michael Gill. Counsel parties, please identify themselves for the record.
Your Honor, Russ Hilliard, Mohammed Hatfield, for plaintiff, Wiggins.
Michael Gill representing myself. Okay, good morning, folks. Now we're here really on Wiggins and Norrie's motion for contempt at this point in time. I'm familiar with the pleadings in this case and have gone through the history of that, refreshed myself with that this morning. Mr. Hilliard, why don't you bring me up to speed on what's happened in the past 2 months since I issued an order allowing Wiggins and Norrie to take discovery and indicating that Mr. Gill will be found in contempt if he cannot fully honestly comply with those discovery requests.
Thank you, Your Honor. This history, Your Honor, is laid out in a motion for contempt that I filed on November 2. As the court indicated, on August 25, you allowed the plaintiff to propound written discovery on or before September 15. I did so on September 7. Copies of the transmittal and discovery requests were provided to this court. The notice I filed on October 18. By your order, the defendant's responses were due on or before October 15. They were not filed by then. They have not been filed as of this morning.
Have you had any communications with Mr. Gill concerning whether he is intending to comply with these? I know he filed some papers indicating he would not comply.
No communications of the ones he copied me on that he filed this morning.
Okay. Anything further?
Just a couple of things. You did in your order 721 specifically put him on notice. They did not comply and fully honestly answer the questions. He may be filed in contempt. He has not done so, Your Honor. William Norrie has no interest other than collecting the judgment it is owed. The interest now is more than $245,000. I respectfully request the court hold it.
What is the number of this one?
Well, the interest is $245,000. Original amount. Original amount is 230 something. My request is that he be held in contempt and that you remand him to custody until he's either answered the discovery in full or paid the judgment in full, including attorney's fees incurred, including today to enforce it. It's Mr. Gill's choice, Your Honor. He should either answer the discovery in full or pay the judgment in full. Your Honor. Thank you.
Mr. Gill.
Well, let's not forget that Your Honor's had 5 cases of mine in a year. You've got 3 judgments, the DRA, the Banking Commission, and with Wiggins and Norrie for $4 million on my business. None of which is true. None of which we have a witness. Listen, 2 million people are going to see this. I've done a meeting with Donald Trump January 8th with the Attorney General's office, and you're all going to jail. I swear to God. You're going to have to explain this. We're going to have to explain how I divorced another judgment for 1 month for $250,000 from the woman who represented me, saying it's all fraud. She's giving state's evidence. I wanted this hearing. This is evidence. All of it's evidence from her. This is the extortion arm. How is it that you get 5 of my cases? Judge Delper dealing with the drug deals in a cover-up. Francois here would leverage me again in a divorce. This is an operation, an AG's operation. In fact, the DRA case was Richard Head. The banking was Richard Head from the AG's office. Summary judgments in both cases that you signed. Now you're trying to get into the business. The reason why they want to look into the business, you had my house to auction. Why did you do that?
But Mr. Gill.
But the business, you're trying to get into the business for the purpose of knowing exactly what I have, so you can build the leverage that you already have. I'm going to have to explain personally the DRA and the banking. This one here, you might get off on, but he's going to jail. Listen, the hell of Central is giving state's evidence to the AG's office. I've got a meeting January 8th, which is on a Sunday.
But Mr. Gill, the point is, you didn't file the brief before the Supreme Court. The Supreme Court then dismissed your appeal.
I did file it. They mailed it. No, those people were working for them. You know this operation. Don't say you don't. You're going to have to explain that.
Mr. Gill, so at this point, what I have before me is a judgment creditor, Wiggin and Norrie, that has a judgment against you, which is now up to $245,000. Now, I've given you ample notice that you're obligated under the rules, under the motion for periodic payment procedures, to disclose your assets. Those assets...
I did disclose my assets.
Not yours, not just the assets you have in your house, but also your business interests. Not the interests of the company, but
Did you know he's connected to the drug dealers? Do you know he's connected to Griner? When you tell the judge about Griner, what do you think this is? Listen, it's all going to come down.
So, Mr. Gill, you have a simple choice here. You have to complete these financial discovery requests. You have to respond to the request for your information about your assets, and that includes assets that constitute shares in business entities. I mean,
that would help with extorting me.
I've gone through the discovery requests that they have sent to you. They are reasonable in scope, and they are entitled to answers to.
You just heard Judge Anderson refer to all the requests of Upton and Hatfield, this asshat, Russ Hilliard, right? Of asking for people's, my employees, the square footage of the property, right? And he said that he looked at it. He said that it was a reasonable scope. I want you to remember that statement. Reasonable, we're talking 1 month where my own lawyer who worked on the case said it was corrupt, in hiding, giving state's evidence for 3 weeks of work. And that trial that they, listen, I know that. You'll have to answer for the IRS and the DRA. I'm telling you corruptly what happened here.
You argued the corruption before Judge McHugh.
McHugh is corrupt. He threw the cake. Listen, it'll all be proven. Just worry about your piece. The DRA and the banking commission will put you in jail. Promise. Because Richard Head's turning evidence.
Do you have anything to say about the motion for contempt? Are you willing to complete these discovery requests?
Yes, give me the recovery request. I'm going on vacation for a while.
Here's the
To
request.
Washington. And listen, under oath, I swear to God.
This isn't going to be a short process. Do you have suggestions to where he might do this?
Well, I can appeal this decision, yeah?
You're going to need to. I'm going to hold.
Interlocutory appeal.
I'm not going to grant that request. You can ask for it, but I can tell you right now, I'm not going to grant you an interlocutory appeal on this. Your choice is to fill out these requests, or I'm going to hold you in contempt, sir. It's as simple as that. I will give you the time to do this now. Instead of holding you in contempt at this point, you can go to the conference room.
Oh, so if I don't do this right now,
Yes.
I go to jail.
Yes.
Isn't that sweet? Now, I'm putting you both in jail. That's a promise.
Understand.
You think that's funny? How did he was using the political figures in Virginia. That was Trump. That was me. All of it was me.
All right, sir. I'm going to move on to the next case. You're going to stay here and fill this out. If you do not fill these out, we will.
I get it.
We will hold
I get it. But you understand what I'm saying.
Understood.
I'll put you both in jail. That's a promise.
Maybe see. Okay, so Mr. Gill, you completed to some extent anyway these interrogatories. Do you, Mr. Gill, what's your position on this one?
These are not full and honest answers, Your Honor, in any respect.
I object, Your Honor.
Well, you have a chance to respond.
Well, you shouldn't be saying it's an honest answer. I gave you an honest answer. It's not his judgment to call it honest or dishonest, especially from him.
Okay, Mr. Gill, I want you to give Mr. Hilliard a chance to speak, and I'll give you a full chance to
Understood.
respond.
Your Honor, your order required full and honest.
Yeah, I understand that, Mr.
The business interest in interacting 9 in particular,
Hilliard. Where are you?
number 9, which is on page
5.
5, Your Honor.
Which number?
Paragraph 9, page 5. He refers you to page 4.
Correct.
Okay.
I think on page 4, there's something about warning specialists, but this information requested about warning specialists here is not provided. And
What are you looking for that you don't have?
I'm looking for the information in paragraph interacting 9, particularly the financial statements of tax returns of bad business, of which he is either the owner or majority owner. Do not provide tax returns or financial statements requested in response to number 5, particularly with respect to the tax returns. I should reference the bottom of page 3, in order to 5I. It says working with AG to something because of corruption. I can't read that.
What page are you on now?
The bottom of page 3, Your Honor, it's actually in order to 5, subpart I, with respect to tax returns.
Right.
I see like I'm writing and I can't. But in any event, that's not a response.
Okay.
There may be others. He put a question mark on interruption number 15, which inquired about the amounts expended by him his campaign for governor in the United States corruption section.
And that's, you're interested in that information?
Because it shows he has plenty of resources available to do all of these things. Therefore,
To satisfy. Okay, Mr. Gill, you further?
There may be others that would like to.
Yeah, I understand.
Thank you.
Well, as the court knows, and Hilliard knows, we haven't filed the taxes in 5 years because it was corrupt. You ruled on the DRA, you know. So you ask the taxes, hey, listen, there's been a couple million videos, right? Don't tell me you haven't seen it with the IRS. So you're trying to get the tax returns, you know that wasn't filed, and I am working with the AG's office under oath. And let's look at the other portion he asked for. State of corruption. Are we to forget that you two guys are stars in state of corruption? You want to rule on that? And he doesn't just ask for it. I'm assuming you read this, Your Honor, right?
Read
Every line? Mr. Hilliard's request.
I've gone through his request.
Wait a minute. Did you read every line, Your Honor? You're asking me to sign it or go to jail. Did you read it?
Sir.
Now, didn't I tell you that reasonable scope? Now, how did he know it was a reasonable scope, Anderson, if he didn't read it? Now, do you know why he claims that he didn't read it suddenly in the same hearing and stammered through the whole thing? It's because he knows it's corrupt and would incriminate him. That's why he was so quick to turn around and say, oh yeah, I agree with Mr. Gill. When have they agreed with me on shit? That's it. This was all corrupt. Your employees, really? Your square footage of your property?
He doesn't get involved in discovery.
Did you read it? I asked you if you read this.
I have gone through it.
So you didn't read it. So
Mr.
before you put me in
Mr.
jail,
Gill.
don't you want to know what says?
Mr. Gill, before, in this case, the court's getting more involved in discovery requests than it ever does. Discovery requests go between the parties. The court is generally not involved in that.
I understand.
I have read these
If you
requests
read
and
this
understand
state
the
of
law.
corruption that you're involved in, which this last video with 2 million hits, explains this. Now wait, listen to what they asked for. You ready? They want all.
What paragraph are you on?
State, page 7, 15. State of corruption websites, including the date on and the amount of each post. Listen, if this is not extortion, we're attacking the state of corruption, which is the one arm that's defending.
Mr. Gill, they're entitled to know what your financial assets are because they're trying to recover on their
But
judgment.
this is not financial assets.
Well, going to what the company, your interest in mortgage
State of corruption. It's non-profit. It doesn't take any money. And the company sponsors it.
How much did you spend on your campaign? That's one of the questions I've asked.
First of all, I don't think he has the right to ask that question, and neither do you. Do you think you do?
He has the right to ask it because he has the right to explore what your assets are, Mr. Gill. That's what you're missing.
Well, what I spent isn't an asset anymore. So if they're looking for my asset, you shouldn't be looking at expenditures, not what I have. Isn't that so?
It's a reflection of what you have and you're under control.
Actually, it's not. A few $1,000s. How's that?
All right.
5 signs.
Mr. Hill, it seems to me what you're looking for is information about mortgage specialists, isn't it? I mean, that's what you focused on at the beginning.
That's what I know about you.
That's what you
Well,
know.
he's asking about state corruption. Right,
Are there questions?
and the governor.
Are there questions you want to ask Mr. Gill about in terms of mortgage specialists, in terms of what percent of shares he has, that sort of thing?
That's what,
Do you want to ask that now?
Why don't you can ask him, Your Honor, if he knows about the taxes. And then you can ask yourself, you ruled on the DRA, you know they weren't filed. And the 11th tax return was forged. And if we were having a witness or a trial instead of summary judgment, you'd know that.
Your Honor, I'll ask you whatever questions you permit me to ask here, but I want to be clear, number one. He's had 3 months, almost 3 months, to file answers to these questions. And we're just dealing with it this morning.
I understand that, Mr. Gill, but I'm suggesting to you at this point, you have Mr. Gill here, I'll swear him in a second. You're trying to recover on a judgment. If you want to obtain information that's going to move the ball forward, why don't you ask whatever questions you think you need to ask at this
I'd
point?
be happy to.
Mr. Gill, I'm going to swear you in. Can you raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth on the pains and penalties of perjury.
I do.
All right, go ahead, Mr. Gill.
Mr. Gill, what business entities do you own any interest in? Or have?
Well, hold on 1 second, Your Honor. Can I also depose him?
No,
Why is that?
because you don't have a judgment.
I got you. All right, go ahead.
What business entities have you held any ownership interest in?
Will you speak up, please? I can't hear you. I'm a little deaf. You know that too. Is there a problem with me not hearing you?
Why don't you articulate the question one more time, sir?
Mr. Gill, what business entities have you had any ownership interest in for the last 5 years?
Mortgage specialist.
Is that it?
That's it.
there any other owner or mortgage specialist? Or
No.
Do you own it entirely?
That's right.
What's the structure of the company? Is it a...
Well, if you asking a question, or is he?
I'm trying to move the ball.
Yeah, right, thanks.
You own 100% of the stock in that corporation?
Well, I guess you just asked that question for you.
Is the answer yes?
Yes, I did.
Does that business have annual financial statements?
We have a controller that would have financials.
Does that business file tax returns?
As we said, as you both know, we filed complaints with the IRS that is being investigated. You heard it. You heard even the IRS turn around on the accident general of the IRS saying we had a mole in my company on tape. So I answered that question.
When was the last time?
11. It was forged.
Mr. Good, you're not going to interrupt him. Let him ask his
Yeah,
question.
go ahead.
Mortgage Specialist Inc. filed any federal or state tax return?
Thank you for asking that. 2011. And Ross, your partner, and Walker forged my tax returns, and we don't have to guess. It's certified. Right, a certified forgery. That you can see. That we put on the internet with the certification.
So you're telling us that Mortgage Specialist Inc. has not filed any tax returns since 2011?
I haven't told just you. I've told everybody. I've gone to Washington and begged them. So the answer to that is yes.
Well,
Thousands of people
Mr.
want to
Gill,
hear this.
we will move this. We'll move through this more quickly if you just answer.
Well, we're going to have to put him in jail. We're going to explain it to him. And then you hear Hilliard on the taxes. Now, how many times and to how many million people have I told you I haven't filed the taxes since 2011 because they forged them? I'm only beating down their door. I only have the adjutant general of the IRS caught on tape saying they got moles. Hey, listen, you guys can come to see me. I keep banging on your doors, but don't worry. I'm dealing with the Attorney General on this, the United States, and Mr. Trump. They're very interested in the IRS, it turns out.
How many places of business does Mortgage Specialist Inc. have?
Places of businesses or locations?
Yes.
3.
Where are they?
Manchester, Nashua, and Plastow.
Who owns the premises in which they operate?
I do.
Individually.
I don't know. What do you mean individually? Does the company own it? Do I own it?
Or is there another corporate structure that owns it?
I believe that there is. I'm not certain if it's under the corporation, under me personally.
Either you own it personally, you own those business premises personally, or an entity.
Speak up, will you?
Mr. Gill.
I can't hear. I can't make
Okay,
myself
but
hear more.
But you're going to be polite in making that request if you're in my court.
Well, then, if he's going to be polite, then why does he turn around and keep whispering after I asked him multiple times not to? He doesn't want to get picked up in the camera. Go ahead.
Mr. Hilliard.
Thank you, Your Honor. Mr. Gill, you're telling us that you either personally own the business premises where the Mortgage Specialist operates, or they are owned by entities which you are 100% owner, correct?
That's correct.
And what is the value of each of those?
I don't know.
Can you describe for the court the location and size of each of those premises?
I don't know. They're about 4,000, 5,000 square foot piece. Commercial space.
How many employees does Mortgage
I
Specialist
object.
have?
Exactly what this does about my income, about now my employees.
I agree.
This is a raid on the company and an information grab.
I agree with Mr. Gill on this. You're entitled to discovery in terms of what the value of the shares in the company are. I'm not sure the number of employees really weighs in on that.
Well, Your Honor, in the absence of tax returns, financial statements, which I asked for 3 months ago, I need some information. The court needs some information to determine if he has the ability to pay this back.
Right. I'm
What
not
does
sure
that have
whether he
to
has
do with
10 or 20
employees?
employees. I'm not sure how that changes the analysis.
Leverage. They want to know who I have.
Well, Your Honor, I need to have access to the business records of Mortgage Specialist Inc. in order to provide information to the court as to the value of that business, the value of his assets, and
He's
And
entitled.
so for 1 month bill, we're going to have my property appraised. For a divorce lawyer who's already admitted the corruption and is in hiding.
But Mr. Gill, keep coming back to this. There's a
Well,
judgment.
no, we're coming back to a corporate rate.
There's a
They're
judgment.
asking employees
There's a
information.
judgment against you for $245,000.
Right, for 3 weeks. Go ahead.
All right. At this point in time, he is entitled, because you haven't paid the judgment. You may have assets to do that, but you haven't
You
paid
were
the
going to
judgment.
auction the house. What happened at the auction? Would you explain that?
They have.
That's personal. This is personal. Why didn't you auction the house?
They're not obligated to auction it.
Well, wait a minute. You threatened me with auction. You scheduled an auction. You did. And him. Why didn't you show up? I intended to put you in jail, but you should have showed up.
Mr.
So
Gill,
why are we into my business when I have a personal asset that could satisfy the judgment?
because a judgment creditor doesn't have to limit his recovery to the asset you identify.
Oh, wait a minute. If the thing's $250,000 and you have something worth, say, $700,000-800,000, it clearly covers the judgment. This is why they use this, and this is why you changed from the auction, is to get into the business and hurt the business, and it's the income. Why do you think he's asking questions about state of corruption and who works for me?
You want the financial statements still of the company?
Yes.
Sir, he's entitled to those. You're going to have to produce those. Do you have those here currently?
I don't have them with me. I didn't give them the accountant yet.
Who's the accountant?
Joe Karen,
Is he a solo or does he work with an accountant?
controller, company.
Is he an employee?
Yes.
You've objected, I know, in the past to people contacting your employees directly. Are you permitting Mr. Hilliard to contact him directly?
He can contact me and I'll contact
Well,
him.
he's contacting.
Do you remember going back to Joe Karen, my controller? You heard Hilliard keep asking for his name. You're hearing Anderson say, can we contact him? Right? Because I didn't want them contacting him because they do extort them, the control of the company. But he would have all the information these bastards want. So why do you think about 3 weeks ago, I remember the video, Accountants' Lives Matter, and I said the Salem cops are threatening my CPA controller for the company? Joe Karen? Well, that's why. Anderson just did it for him. Because I just ambushed that attempt of extortion. You understand? That wouldn't have happened but to get this. This is why we're in the 9th inning. There isn't anything behind this, or them shutting me up and shutting me down, or them going to jail. Those are our
I'm
choices.
going to give you 2 weeks. Today's the 29th.
Well, wait a minute. You're going to have to make a judgment. You didn't even read this. You're giving me 2 weeks, and he's asking for every ad I put on state corruption and how much I spent on it.
I don't think he's interested in that as much. Is that fair to say, Mr. Hilliard?
I'm interested in any
Of course he's in.
statements about the company or Mr. Gill personally.
Okay.
So you're ruling that he can go over, and I have to give him an itemized thing on everything I spent on state corruption that I've done for many years.
I'm not ruling that. I'm ruling that you have to give financial statements of the company. How much time do you need to do that?
I'd have to ask the controller. He's the one handling it. As you can see on mine, I deal with very few finances.
It was sparse on details. You're right about that.
What is it?
There were not a lot of details in your interrogatory answers. I'm agreeing.
Everything I gave was honest. Let's not forget, this is corruption.
I'm going to give you till December 20th, so I'll give you 3 weeks to comply with that. You have
And to comply is the financials of the company.
financials of the company. Anything else you're looking for at this point, Mr. Hilliard?
Yes, Your Honor. I want any information establishing his net worth or income. He says there's no income tax returns. I want to have any...
You know something? They wanted for the divorce court, but good. I'll give it to you. Just to show you everything that I'm putting down is 100% accurate.
All right. You've asked for bank statements?
Bank statements, personal financial statements,
None?
Well, wait a minute.
What are you asking for bank statements of?
any
Personal or corporate?
corporate and personal, Your Honor. He's personally responsible for this judgment.
I mean, the point is, Mr. Gill, there's a judgment against you. You've gone up to the Supreme Court. You've come back.
Well, we didn't go to the Supreme Court. The woman working for this guy was also under investigation. Carrie Lemieux was supposed to send it there. Only to the same woman who judges everything from McLean in the Superior Court, picks it all out. This is being investigated. Trump's guy's right here now. All right? Smile for the camera.
Understood, sir. But there's a judgment. Maybe that judgment's going to be taken away at some point, but right now there's a judgment against you. You've got to pay that. And if you don't pay it, they're entitled
Not
to
if I can send you to jail first.
All right.
There's no race.
You have until December 20th to submit financial statements of the company, to submit any net assets. You have statements showing your own personal net assets and personal and corporate bank account statements. Understood, sir?
I understand. What we have in this hearing is hard evidence and extortion. And this is what I am taking to President Trump and your new Attorney General, Sessions. And we are going to change this state. We have got them all connected. I am getting more and more evidence about the hospitals and who owns them. That's going to be a big surprise. The transportation of these drugs through the state. I'm getting more and more people to come forward.
It would be much easier for me to walk away altogether and be done with the entire mess, but I want to expose what has gone on. I feel obligated to do so. I learned that Steve Tober would be adverse counsel. I knew Tober as he represented Wiggin and Norrie and had even represented me personally on a sensitive matter. I also knew that Tober was very close to Ross, that the two were good friends, and that Tober had previously represented Ross. From the time Tober first appeared in the case, his litigation tactics were extremely aggressive. Tober took a scorched earth approach. Tober's approach would be to excessively build a divorce case, all of which would unnecessarily lead to increased legal fees for Gil and depletion of the marital estate. Eventually, it would become clear to me that the goal of Ross and Tober collectively was to extract considerable legal fees out of a once sizable marital estate. In December 2007, Gil became uneasy with Ross as his attorney. I recall numerous telephone calls and in-person conversations with Gil, where he informed me that he was not comfortable with Ross as his attorney. I told Ross early on that there was a conflict of interest given the aforementioned legal representations and relationships. I then directed an associate, Megan Beauregard, to perform legal research on the ethical issues involving conflicts of interest. Following our research, I concluded that a material conflict of interest existed and that we needed to disclose the same to the client. At the time, I did not know, but would soon learn from my associate conducting the legal research, that Ross, too, had been represented by Tober in cases involving ethical and legal malpractice violations. Given the above, I prepared a motion to disqualify Tober as attorney for Mr. Gil's wife in the divorce. The basis of the motion was the aforementioned conflicts of interest, the overall impropriety, and the potential significant compromise of the client's interests in a hotly contested divorce. I had countless discussions with Ross regarding the issues of the conflicts and argued strenuously that we move forward on the motion. On several occasions, I asked Ross why he would not permit me to simply talk to the client about the conflicts issues, especially since I had come to learn that Ross, too, had been represented by Tober. I could not understand why Ross was so insistent in his refusal to seek to disqualify Tober. I became so frustrated and distraught over these issues that I began to confide in several people close to me about the ethical dilemma. Specifically, I talked to Megan Beauregard, as well as my then-current husband and even a relative, all with the single goal of trying to find out why a senior partner at my firm would block the disclosure of a conflict of interest. Up until this point in time, I had only the highest regard for Ross. I worked extremely hard on his cases and felt fortunate to work with him. Gil was unaware of the conflicts of interest relating to Tober's prior representation of me, Ross, and Wiggin and Norrie. However, from the inception of Tober's involvement, Gil was uneasy with having Tober involved in the divorce because just prior to Tober's appearance, the records of a therapist, Dr. Broussard, went mysteriously missing while Gil's wife was represented by attorneys Rona Wise and Matthew Kozel. As I mentioned, in December of 2007, Gil became uneasy with Ross as his attorney. Gil expressed concern that a plan existed between Ross and Tober to build the divorce case excessively. Gil was concerned that Ross did not want to have any contact with him. On numerous occasions, I continued to inform Ross that Gil was uneasy with Tober's involvement and was likewise uneasy with Ross's representation of him. I implored Ross to speak with Gil regarding Gil's concerns. However, Ross did not want to deal with the issue of whether a conflict existed by virtue of Tober's involvement, and Ross would not speak with Gil. In Ross's opinion, no conflicts of interest existed by virtue of Tober's involvement. Ross never discussed with me the subject of Tober's prior representation of him. Again, I could not understand why Ross seemed to be fighting not to move to disqualify Tober. During this time period, the global economic crisis had begun, and there were numerous in-firm discussions about rainmaking and billing clients. It became clear to me that I was being set up for something, and that if anything went wrong with the divorce, I would be blamed. Indeed, I knew that eventually the aforementioned conflicts of interest would lead to real problems with the client. I informed Tober of the motion, and it was clear that he was troubled by it. For example, at a court hearing following having advised Tober of the motion, Tober appeared to be trying to intimidate me by standing uncomfortably close to me, scowling and generally looking threatening. I also began to realize that Ross's behavior in litigation style became unusual. For example, Ross informed me that if and when Sarah Gill's deposition would go forward, he would aggressively explore incidents of sexual abuse she suffered in her past. Doing so, however, would not advance the interest of Gill nor be relevant to any issues in the case. It was also out of Ross's character to engage in such lines of inquiry. It then became obvious to me that this line of inquiry would only be used to delay the litigation by forcing Tober to stop the deposition. Indeed, Ross was so committed to preventing the deposition of Sarah Gill in order to allow the extremely lucrative, approximately $100,000 per month case to continue, that he told me that Sarah Gill would never sit for a deposition. Ross said that either Ross or Tober would feign a heart attack or some other medical problem in order to stop the deposition. Ross told me multiple times that Sarah Gill's deposition was simply not going to happen. Meanwhile, it seemed as though every effort I made to advance the case was being thwarted. For example, I tried for many months to secure the deposition of the opposing party, Sarah Gill. Yet, when I would discuss this with Ross, he seemed unconcerned that we were unable to secure the deposition. Likewise, as discussed below, Ross was unconcerned and uninterested in the mysterious unavailability of Dr. Broussard's records. While Ross and I had worked closely together for years, there was now obviously sharp tension between us, and he was beginning to communicate less with me. I began to believe that Tober and Ross were in constant communication and were conspiring to frustrate the case from being advanced to closure. During this time frame, Wiggin and Norrie's financial challenges became more acute. For example, there were no bonuses distributed at the end of 2008, and the litigation activity in the firm had declined precipitously. The firm had many meetings regarding its financial challenges and the economic slowdown generally in the legal profession during this economic recession. As the case continued, it became clear to me that anything concerning the case which I would tell Ross would soon be learned by Tober. I concluded that Ross was not representing the best interest of the client, but instead was acting in collaboration with Tober to continue the case and continue the sizable monthly legal fees being paid by Gill. Despite all the fees and my best efforts, depositions had been blocked or thwarted, and other depositions, such as Sarah Gill's, as noted above, surely would not take place under Ross's watch. I no longer trusted Ross. I stayed out of the office as much as possible. Occasionally, Ross would call me and inquire about the case. His most common question was to inquire about the client's current thinking. Through my conduct in the case, I began to make it clear to Ross that I would not be a party to what I saw as unethical conduct, and this created greater distance between me and Ross. Eventually, this friction was expressed in an email response that I had sent to Ross. He had asked me, in an email, to engage in some ethically questionable conduct, and I responded that I would not do it. By this point, I was close to leaving the firm. I did express to Ross the client's displeasure with the case, the lack of depositions, and other related issues. I informed Ross that the client wanted to interview other law firms. I soon interviewed William Levine of Lee & Levine in Boston, Massachusetts, as potential successor counsel to Wiggin and Norrie. I explained to Levine that depositions had not been conducted, that discovery efforts were being thwarted by Tober without resistance from Ross, and that we had not obtained the therapy records of Sarah Gill. I said that I needed to find successor counsel who could properly represent Gill's interests. I also informed Levine about Ross's conflict given Tober's involvement and Ross's apparent efforts to force the expensive case to continue by delaying necessary proceedings, among other things. They listened to what I had to say and agreed to a second meeting. After listening intently to the challenges I was facing in representing Gill, Levine advised me that the situation would not likely end well with Wiggin and Norrie. He then gave me the name of another lawyer with an expertise in ethics. That lawyer, who also listened intently as to what I had to say, advised me to leave the law firm of Wiggin and Norrie. As for the therapy records of Sarah Gill, they had been in custody of her therapist, Dr. Broussard. At various times, Dr. Broussard's office had represented that the records didn't exist due to 1, a water and flood problem, 2, a fire, and 3 an accidental shredding by Dr. Broussard's secretary. Broussard's office even stated that the records might be in storage. Ross rejected my efforts to challenge in court these suspect and inconsistent grounds for allegedly not having medical records. I came to the conclusion that Dr. Broussard's records may not, in fact, have been destroyed, given my review of the records of Dr. Garber, which note that he reviewed Dr. Broussard's records in which detail a conversation Dr. Garber had with Dr. Broussard, wherein Dr. Broussard acknowledges the existence of the records. From time to time I had heard Ross make highly derogatory comments about Gill. This was unusual, as he typically did not make such comments about his own clients. Later in the case, as I began to understand what was happening between Ross and Tober, I reflected upon the fact that Ross strongly encouraged me to communicate with Tober by telephone rather than in writing, even insisting that I do so even though every phone conversation I had with Tober would subsequently be misrepresented by Tober, leading to follow-up letters, disputes, delay, and more legal fees. For this reason, I had long preferred to communicate with Tober in writing so as to eliminate such unnecessary work and delay. Ross never explained to me his rationale for why I should only communicate with Tober via telephone and not in writing. At some point toward the very end of my relationship with Wiggin and Norrie, I told Ross that I know what's going on here. I recall making a statement along the lines of, "How much money do you need?" I gave my notice to Wiggin and Norrie, advising them that I would be leaving the firm.